You're watching a nominee quote her own statement about the rule of law, then refuse to apply it to the president who nominated her. Representative Raskin just read back her words. If any political figure can direct federal law enforcement against its critics, we no longer live under the rule of law. Then he asks if she rejects Trump's public orders to investigate and prosecute James Comey, Leticia James, Schiff, and others. Her answer isn't, yes, I reject that. It's, if there's reason and evidence to investigate those people, then he's absolutely right to call for it. Raskin is stunned. He points out that grand juries refused to indict, prosecutors resigned or were forced out because Trump is attacking perceived political adversaries. Isn't that exactly what your statement condemns? She says she can't speak generally without knowing all the facts about each individual. Then Raskin reads another of her statements. It's impossible to sustain lawful governance when a leader holds office in defiance of his own electorate. He asks if she'll apply that to Trump, who claimed he won 2020, lost 60 court cases, incited an insurrection, but still claims he won. Her answer, he ceded power. President Biden was sworn in. Raskin responds, so because the coup didn't work and the violent insurrection didn't succeed, you think it was all right? What you're about to hear is how a nominee's stated principles dissolve when applied to the person who controls her career.
Raskin, the ranking member.
Mr. Chairman, thank you very much. And Ms. D'Andrea, I'm moved by some of your political statements. One of the things you said at the end of last year was, if any political figure or party can direct federal law enforcement against its critics, we no longer live under the rule of law. Do you remember when you wrote that?
Yes, sir.
So do you reject Donald Trump's very public orders to the Department of Justice and the FBI to investigate and prosecute James Comey, Leticia James, Schiff, a bunch of other colleagues, including Jason Crow?
I would say if there's reason and there's evidence to investigate those people, then he's absolutely right to call for it. If not, then he doesn't need to call for that.
Wait, you said if any political figure can direct federal law enforcement against its critics, we no longer live under the rule of law.
I think there's a difference between someone being critical and someone doing something that violates the rule of law.
Okay, but all of it, I mean, the reason why all the grand juries refused to render indictments, the reason why a number of prosecutors resigned or were forced out of their positions were because of the obvious point that Donald Trump is attacking them because he perceives them to be political critics or adversaries of his. And so it would seem to me, just to apply your rule to the facts of the situation, Donald Trump is absolutely taking us outside of the rule of law. I mean, I don't mean to embarrass you in any way, but I liked your statement of principle, and I'm just willing, I'm wondering whether you're willing to interpret it in a completely obvious and objective way.
I would say that my interpretation is objective, and I think that without having all the facts about each of these individuals and each of the allegations allegedly, against them, I can't speak generally to the president's statement. I stick by my original statement.
If any president, whether it was Maduro or Trump or Oscar Orlando Hernandez, says, I want you to go and investigate and prosecute these 20 political enemies of mine, your position would basically be agnostic. Well, let's wait and see what happens in the investigation. Is that right? Doesn't that defeat the whole point of your statement?
Respectfully, that's not right. That's not what I mean. That's not what I intended to say.
All right, well, let me ask about another one. I wish we had all day, because you've said some interesting things, which I agree with at the level of generality at which you stated them. For example, you said that Maduro had refused to cede power. I think it was in the 2024 election, and you said that it's impossible to sustain a claim to lawful governance by a leader who holds office in defiance of his own electorate. Well, that really made me think about what happened in 2020, when Donald Trump claimed that he won the election, but the Congress found that he had not won the election. 60 federal and state courts rejected every claim of electoral fraud and corruption. But not only did he claim that he won it, he continues to claim that he won it. So I hope you would repudiate that.
Thank you for the question. I would say that he was he ceded power. He gave in. The President Biden was sworn in and was the president of the United States. So he did not illegally hold on to power in the manner that President Maduro, illegitimate dictator, did.
Oh, I see. In other words, because the coup didn't work and the violent insurrection didn't succeed in overturning the election, then you think it was all right what he did.
Respectfully, that's not what I said.
I said that's what I said, though. In other words, you seem to be saying that because his attempt to destroy Joe Biden's electoral college majority, which he won by more than 7 million votes, 306 to 232 in the electoral college, because his efforts to overturn that on the floor of Congress and with a violent insurrection, then he complied with what you were stating as a basic rule of law principle.
Respectfully, sir, I think there's a difference between asking whether fraud occurred and refusing to cede power once it's been made clear to you that it hasn't.
Well, what's inciting a violent insurrection against your own government?
I'm not sure I understand what you mean.
Well, you're saying there's one thing about asking a question, for example, going to 60 different federal and state courts to try to get a ruling, but once you've lost all of those, you think it's legitimate within the rule of law and democracy to incite a violent insurrection, as Donald Trump was impeached for?
Sure, I appreciate the question. I don't have a clear answer for you on that.
Okay.
I think the evidence.
Well, we can discuss it later. And I thank you for your statement of principles, which I think are often quite lucid, but I wish that you would apply them even-handedly across the board. It might be tough from the job that you're in right now. I yield back to you, Mr. Chairman.
Mr. Chairman.
What happened in that hearing wasn't just political evasion, it was a demonstration of how stated principles become conditional when the person judging you controls your future, and why that conditionality matters when the nominee will make decisions about law enforcement independence. If you understand what she wrote, what Raskin asked, and how she answered, you'll see how accountability disappears when power decides what rules mean. Start with her own words. The nominee wrote that if any political figure can direct federal law enforcement against its critics, we no longer live under the rule of law. That's a clear principle. It doesn't say, unless there's evidence. It says, if political figures can direct prosecution of critics, rule of law is gone. The conditionality is in the direction, not the evidence. Leaders shouldn't be able to order investigations of political opponents regardless of whether evidence exists, because that power itself corrupts the independence of law enforcement. Then Raskin tests the principle. Trump publicly ordered DOJ and FBI to investigate and prosecute James Comey, Leticia James, Schiff, and others. Does she reject those orders? Her answer rewrites her own principle. She says if there's reason and evidence to investigate, Trump is right to call for it. That's not the rule she stated. Her rule was about direction by political figures, not about whether evidence exists. She's retroactively adding an exception that makes the principle meaningless. Any leader can claim there's reason to investigate critics. That's why the rule exists, to prevent leaders from using claimed reasons to weaponize law enforcement. Raskin points out the obvious flaw. Grand juries refused to indict. Prosecutors resigned or were forced out. The pattern shows Trump is targeting people he perceives as political adversaries, not people who violated law. She responds that she can't speak generally without knowing all the facts about each individual, but her original principle didn't require knowing all facts. It said that if political figures can direct enforcement against critics, rule of law is dead. Now she's saying she needs to evaluate each case individually, which is exactly the kind of case-by-case assessment that allows political pressure to masquerade as legitimate investigation. The Maduro comparison exposes the double standard. She wrote that it's impossible to sustain lawful governance when a leader holds office in defiance of his own electorate. Raskin applies this to Trump, who lost the 2020 election, lost 60 court cases challenging it, incited a violent insurrection to prevent Biden's certification, but still claims he won. Does she repudiate Trump's conduct under her stated principle? No. She says Trump ceded power and Biden was sworn in, so Trump didn't illegally hold power like Maduro. That's outcome-based reasoning masquerading as principle. The principle she stated wasn't about whether someone successfully held power illegally. It was about whether someone attempts to govern in defiance of the electorate. Trump attempted to overturn an election he lost. The fact that he failed doesn't mean he complied with democratic norms. It means the institutions he attacked were strong enough to resist. Her logic says that as long as a coup fails, it doesn't violate the principle. That's not a principle. That's results-oriented excuse-making. Raskin makes this explicit. He asks if inciting a violent insurrection to overturn an election you lost counts as defying the electorate. She says she doesn't have a clear answer, but her statement about Maduro was crystal clear. The difference is that applying it to Trump would disqualify her nomination. So instead of applying her principle, she finds reasons why it doesn't apply. That's not legal analysis. That's political calculation. The pattern reveals the dynamic. Nominees state broad principles that sound good in speeches and writings. Then when confirmed, they interpret those principles to exclude the conduct of whoever appointed them. The principle becomes a tool for criticizing opponents while excusing allies. Rule of law rhetoric without rule of law application. What makes this particularly troubling is the position she's being nominated for. If she's unwilling to apply her own stated principles to Trump when her nomination depends on his approval, why would anyone believe she'll enforce laws impartially once confirmed? The confirmation process is the moment when independence matters most, because it's the last time the nominee faces public accountability before gaining power. If she won't stand by her principles now, she won't suddenly develop a spine after confirmation. The "I don't have all the facts" defense is revealing. She had enough facts to condemn Maduro's defiance of his electorate. She didn't say she needed more information about Venezuelan election procedures or judicial review before concluding Maduro lacked legitimacy. She made a principle-based judgment. But when asked to apply the same principle to Trump, suddenly she needs all the facts about each individual case. That's not rigor. That's selective application. If any of this concerns you, demand that nominees either defend their stated principles or admit those principles were never sincere. When someone writes that directing law enforcement against critics destroys rule of law, then defends exactly that conduct when their patron does it, they've shown you what their principles are worth. And when they get confirmed anyway, you learn that stated values matter less than political loyalty in determining who gets power.